Impugned judgment is set aside. Appeal is allowed. Appellant be set at liberty forthwith.
Highly obliged, Lordship.
Items 53 and 54.
Revision is partly allowed. Connected revision is also partly allowed.
Obliged, Lordship.
Item 55.
Bail petition stands allowed.
Obliged, Lordship. Right.
Allowed.
Obliged, Lordship.
57.
Allowed.
Objection. 8.
Allowed.
Objection. 9.
Allowed.
Objection.
Lordship, item number 2, kindly want to withdraw.
You are?
M. Rahman.
Your name?
M. Rahman.
Item 1.
2.
The prayer of Mr. M. Rahman. Matter is dismissed as withdrawn.
Lordship,
May I please, Your Lordship? I beg to mention item number 17, my lord.
Yes.
This matter will be taken after a week, my lord. There are some difficulties today.
Prayer of learned counsel for the petitioner list the matter again on. Yes.
No, item 5, we had filed our wakalatnama today. Kindly call for it.
Call for the wakalatnama.
File today in the morning for the informant.
I do. 5.
5.
May I please, Your Lordship? I beg to mention item number 21, my lord. Yeah, also, my lord. Can it be after a week, my lord?
All right, same order. 21.
Objection. May I please, There is an interim order.
Interim order plus earlier to continue.
Consent of the other side, I'd like to mention item number 9 of the daily list.
Yes. 21.
Item number 9, daily list.
Yes, when do you want?
2 weeks. Much. Obliged.
My pleasure, Lordship. Lordship, with the consent of the other side, I beg to mention item number 12, my lord.
Hmm?
Item number 12.
12.
Already taken a step, consent, my lord.
Prayer of learned counsel for the petitioner. The consent of the other side. List the matter again on.
Time for the petition.
Interim order passed earlier to continue.
Time for the petitioner, Lordship.
This is on behalf of respondent.
Respondent, Lordship.
Okay, change it. No?
Interim may be continued.
May I please, Your Lordship, with the consent of the opposite counsel, I beg to mention item number 10 of daily list. Kindly adjourn the matter for the day.
All right.
Lordship,
Great.
kindly
Yes.
matter may be fixed on 25th of February.
All right, 25th February.
Bless.
Please, Lordship. Lordship, I beg to mention one item, my lord, that was listed on 28/6/2024, my lord. Supposed to list after 4 weeks, my lord. Some interim order is there, some sorts of urgency is there. So I may be allowed to list the matter next week, my lord.
Lordship, I beg to mention item number 20 and 22. Lordship, that may be adjourned for the day.
All right. 22.
20 and 22.
20 Lordship, charge sheet submitted in this case.
Have it done.
May I please, Lordship? Lordship, I file a petition under sections 483 of BNSS, which is regular bail for accused to Suruz Ali and Manjura Khatun, was arrested on 28/8/2025. Today's day completed it 156 days. And under sections 103, subsection 1 and 3, subsection 5, BNSS.
All right, CD.
Can go charge sheet case.
Sir, seated case. sir.
Charge sheet.
Yes.
Can
Can go please here. Along with CD.
Let me fix.
ऐसा 3
Always, sir.
के जने हो राखी
Lordship, kindly pass over item for time something.
16. One is it? This one I
All right, timing.
Yes, Your Lordship. Done people right to obtain instruction that any case is registered or not. There is no FIR case, but police is harassing me, Your Lordship. We have not received any instruction report regarding.
Learned additional PP submits that no instructions have been received from the learned
Okay, since
proceed. Please taken on so and so. In the meantime, no coercive action shall be taken against the petitioners.
10-2. Four two. Instruction. 4-2. Oblige. On a case.
All right, timing.
May I please also for it into application also. FIR also find at page 15. Allegation that here the petitioner had some relation with the lady, and thereafter as he has not married her, she has filed the case. That they had live in relationship. Actually, the informant she is his friend's sister-in-law, and he helped her in getting the divorce. Thereafter, she had some relation with him. Now she has, because he has not married her, the present FIR has been filed. Moreover, the present petitioner is a married man. He is 46 and she is 35 years old. As per her allegation is since 2019 they had live-in relationship, those things. Now they in 3/11/2025, the present allegation has been lost. Maybe a case of 318 BNS. The available offense.
Heard learned counsel for the petitioner and learned PP. An application under so and so. Informant and accused are both middle-aged persons. It appears from the contents of the FIR that they were in a consensual relationship. The allegation is that the petitioner, upon promise of marriage, entered into a live-in relationship with the informant. Admitted that the petitioner is a married man. Call for the CD era, provided that in the event of his arrest, the petitioner is on interim bail of rupees 50,000 with 1/3 like amount satisfaction of the
Massive.
acting authority.
18-2.
Appear before the IO within a period of 7 days and cooperate
Lot-
with the investigation.
Lordship.
Wait, please. No, your lordship will find the FIR, my lord, at page, my lord, 9, my lord. Small FIR, my lord. My lord, I am on behalf of that, my lord, Ashik Ahmed, my lord. My lord, I have narrated my fact, my lord, at page 4, paragraph 7, my lord. Paragraph 7, my lord, sixth line, my lord. On the evening of 16/1/26, an altercation took place in between the FIR name accused Dipanjali Medhi and the deceased person, namely so and so, on the road near the office premises. Upon noticing the said incident, the petitioner, along with other office staff, intervened the matter so that nothing will happen. The FIR name accused Dipanjali Medhi and the deceased had in relation, and the altercation might have taken place as a result of misunderstanding of them. The whole incident was fully covered under CCTV, my lord. He intervened, my lord, but so far the case is registered under, my lord, 108, my lord, the 306 of the IPC, my lord. The abatement of suicide is not there, my lord. Abatement part is not there, my lord.
Since it is, he claims it is covered by CCTV,
Yes, ma'am.
that will show.
Yes, ma'am.
I'd learned counsel for the petition. Additional PP. This is an application under so and so. It is. Paragraph 4. File petition. Is submitted that the petitioner who is running an institution regarding admission consultancy for various courses intervened between a fight that took altercation that took place between the FIR named accused Dipanjali Medhi and the deceased, both of whom were they were students or they were customers.
Actually, they were student, but they're part-time employee.
Is Dipanjali and Manav
Yes, ma'am.
But
Understood?
students as well as part-time employees of the institution. stated that the whole incident is fully covered by CCTV, which will reveal the actual fact. Para, call for the CD. Interim 50,000, okay. Before the IO in 7 days.
But I'm obliged, madam, deeply obliged.
Will kindly see the FIR, which is your lordship will find the contents of the FIR at page 13, which is type copy. And if your lordship for a moment see at page 17, very tiny, it is in English. Page 17. Lordship has seen 17, serial number 12. Now you go back to at page 13, this is what has been done. This is not an SMS where, so there will be, hope so there will be no mistake in it, because this is exactly is applica. Now please 13. Now on a complaint namely so and so, daughter of late Prasanjit Kolita, aged about 28 years, resident of so and so, submitted written petition stating one name against Mr. Kaushik Das. So present petitioner is Mr. Kaushik Das, aged about 29 years, resident of so and so, for committing serious cognizable offense. That Mr. Kaushik Das and complainant came into a relationship on 8th of March in the year 2020. Please, my lord, kindly note down it is in the year 8th of March 2020, their relationship. And from the very inception of the relationship, Mr. Kaushik Das has repeatedly promised to marry her and portrayed me as his future wife. In furtherance of such promises, he proposed her with an engagement ring in the month of February 2021. Everyone, including friends and family members of both of them, knew about it regarding the engagement ring. Thereafter, he even took her to stay with him in his residence of Delhi with his father, was undergoing a medical treatment at Medanta Hospital, Delhi. During the period, complainant so-and-so stayed with him and his family members and took care of his ailing father and other family members in June 2023. Then subsequently, around the last week of March 2024, he again took her to Delhi when again his father was undergoing medical treatment. Complainant stayed there with him and his family members, period, did most of his course, and as a result of this, he had to miss many posting of his medical internship, for which he got extension later, which adversely affected the medical academics. From 10th of May 2024, upon the date of his father at so-and-so, I accompanied him with his mother and sister from Delhi to his house at so-and-so. In the period, he repeatedly assured her that he would marry Jessica Kolita in front of his family members, thereby gaining her complete trust and emotional dependence. He even further executed a written declaration on stamp paper dated 13 September 2020, wherein he promised to marry, believing his promises of marriage to be genuine, including the assurances of him and his family members, relying upon the assurance of him and his family members, as well as the written declaration signed by him on a stamp paper. Complainant consented to physical relationship with him. However, shockingly, it later became apparent promise of marrying was false, dishonest, mainly solely on the purpose of so-and-so exploiting her, thereby vitiating her consent. As a result of his marriage promises, she became so-and-so pregnant around 10th of July 2024. But when she informed the accused and family about the pregnancy, instead of taking responsibility, that subjected me to threat, pressure, and emotional coercion to terminate the pregnancy against her wishes. Under extreme mental pressure, fear, and emotional manipulation, stress of her medical studies, complainant was forced to undergo an abortion which caused her immense physical pain, trauma, and severe psychological suffering. After abortion of the accused and his family members refused to marry her, started avoiding her, verbally assured her, abused her, humiliated her, blamed me for pregnancy, and even threatened her not to disclose the truth to anyone, otherwise he will make her life hell. As a result of this, he could not fill the form of NEET exam, nor did she was able to sit in the NEET exam. The intention accused was dishonest from the very beginning, as he induced me to a sexual relationship solely on a false promise of marriage for his own sexual gratification due to the accused continued emotional abuse, harassment, betrayal, abandonment of him and his family members. Complainant fell to deep depression, emotional distress, and finding no alternative. Unable to bear the unbearable conduct accused, he attempted to so and so on 2 occasions, not as he felt completely helpless and broken. The reports and record of such suicide attempt to the hospital is attached here with the accused was fully aware action and those his family members were pushing her towards mental breakdown, self-harm, adversely affected her medical academic despite her knowledge. Members deliberately continued her abusive, so and so. So this is the contents of the FIR, Maya. From 2020 onward, they had a relationship. The family members also aware of it till 2025. Now, the registration of the case at page 16 kindly be looked into it, my lord. 16 is under section 3182, which is cheating, my lord. 64B, BNS, rape, and 69, sexual intercourse by employing deceitful means. If you see this section 3182, 64, 69, see 89 is causing miscarriage without so and so, and 351 is criminal intimidation. Now, my lord will be kindly see who had cheated, and she said there is a promise to marry. From 2020, they are adult. They are adult, they are not a minor. So one is 28, one is 29. Accompanied because my father was unable, was unwell. He was a cancer patient. So we took him to Vedanta. She accompanied, the family members also aware of it. Today, she is saying that no, there is a promise which has been made. Now, please see the WhatsApp message. Kindly see, I will not read it. It will be very embarrassing to read this. See page 19. See page 19. Page 19 is WhatsApp message. Kindly see the first. Left side is the informant. And tick mark, 2 tick mark is the accused. Kindly see, my lord. From this is started 2025. Kindly be see, my lord. Lordship got it?
Yes.
I'll just not read. Kindly see 20. Kindly see the first on the top. Kindly see on top. Page 20. Kindly see on the top.
All right, Mr. Bhuya, his arrest can wait till the CD.
My lord,
His arrest can wait till the CD comes.
may I, without my lord is granting interim, my lord?
No, no,
No. He can wait.
no. Police can wait.
No, my lord, then I have my submissions to
Yes,
make
yes.
it, my.
Yes, yes. Okay.
The thing that has been projected in the petition on the basis of WhatsApp messages, my lord, is the half truth. My lord, I am producing a document. Will kindly see to it. Now, it's a distinct offense under section 69. Prior to my lord 2024, it's a in his handwriting, wherein this girl, my lord, lost her father at the age of 9 months. On pension money, she has been brought up. In Instagram, she has been stalked, and thereafter friendship has been made. Promise in writing. And the document I have submitted, my lord. It had it. 70. Problem.
Deeply obliged.
Also, in this case, they are supposed to bring instruction whether charge sheet has been submitted or not. He is behind bar for 79 days, 60 days offense.
We have communicated with instruction because first it is submitted, Lordship.
When?
10/1/26.
That is within
10-1.
10/1.
10-1/26.
within 60 days.
Within 60.
Then we have to go on marriage.
Lordship, then your lordship, these are allegations, your lordship. Page 14, your lordship. Was by one. There is a demand, your lordship, they say. So far as this format is concerned. But no payment of SI material, your lordship, trial will be conducted, your lordship. Of SI material, your lordship, trial will be conducted, your lordship. And he will face the music if he cannot defend himself at the relevant time. Further custodial detention may not be required, your lordship. That's my only case.
How many days?
79 days, your lordship. Offense is 60 days, your lordship. But your lordship, they have submitted their arrest course 7. Own arrested in this case, your lordship. At least he will get.
Even if that is called for, then also length of detention will be the count.
That's
This. Even if the CD reveals
Sure.
everything. Third, Mr. For the petition and learned ladies, if it is an application under so and so. As per the allegations contained in the FIR, the petitioner along with some other persons demanded an amount of rupees 5 lakhs from the informant at the time of Diwali and threatened to disrupt their business of selling firecrackers unless the payment was made. Subsequently, an amount of rupees 1,50,000 was handed over to the accused number 2, Vikrant Kolita. Learned additional PP has informed the court that charge sheet has already been submitted within the statutory period. On the other hand, learned for the petitioner admitted that since the investigation is already over, the petitioner will face the trial, and considering the length of detention of 79 days, he may be granted bail. Having regard to the effect of completion of investigation, nature of the allegations, as well as the period of detention, the prayer for bail is allowed. 50,000 two sureties. And additional PP of. And PP কথাটা জোট লিখিছিল. This has been submitted and praised that the scanned copy of the TCR and CD may be called for. Order provided petitioners shall participate regularly in the trial. If one commences, will not try to influence, imitate the witnesses in any manner.
May I please, Doctor? A GD entry has been made against the petitioner, my lord. The petitioner is running a tour and travel agency, my lord, wherein the informant booked a ticket, my lord, for touring, my lord, for Colombo, my lord. And that package has been cancelled, my lord, due to which she has to refund the money, my lord. So what happened, my lord? Lordship may kindly at page 4, my lord. At page 4, para 4, my lord. This person of Tezpur PS, my lord, call her and she appeared before the police station, my lord. And they threatened, my lord, and she has to pay the 40,000 rupees in presence of the police station, my lord. And she has issued a post-dated check also, my lord. That I have annexed, my lord, will find at page 14, my lord. 31, my lord. 31/1/2026, my lord. Police, without registering an FIR, my lord, they are threatening the petitioner to pay the money, my lord. Still today, no FIR has been lodged, my lord. Only GD entry has been made, my lord. They are not issuing any notice also, my lord.
No FIR.
No FIR, only GD entry has been made, my lord. Textbook PS 16 oblique dated 3/12/2025, my lord. On the basis of that, my lord, they are calling the petitioner, my lord, and they are threatening to pay the money, my lord. Some package has been cancelled, my lord, and she has not got the refund, my lord. So they have some alternative remedy also, my lord. Without registering an FIR, my lord, they are threatening the petitioner, my lord.
After some time, we have taken instruction any cases registered against this petitioner or not.
My lord.
Yes.
May I please? This is an LIA case, my lord, where one Devo, Zenith and Electors Private Limited has been made an accused in this case. It's a private limited company. There one Prabir Kumar Bhattacharjee, managing director, has been made an accused, my lord. And insofar as Prabir Kumar Bhattacharjee, managing director, there is no averment in the complaint that he is the managing director. Your lordship goes to the complaint that is in page 12, my lord.
What are we supposed to do today? Everybody has appeared, I think.
Yes, everybody.
Then
PR has been called for, my lord.
Taken up for disposal today, Your Lordship.
thing received. Here,
Required probably.
not received.
Can be disposed of in the admission stage, so it's.
But before that, we have to receive the PCR.
This scan copy is required, ma'am, because we don't know what is the initial deposition also. That is to ascertain whether that is there or not.
The hard learned counsel for the petitioner as well as learned counsel for the respondent. It appears that the TCR has yet to be called for. Hence, call for the scanned copy of the TCR. Is the matter again on so and so for admission? Interim order passed earlier shall continue till the next date of listing.
Item 11.
My lord, the petitioner is not there. One occasion previously also they were not there. The subject matter is very minimal. It may otherwise be taken up for disposal.
You are for the
Respondent.
private respondent.
Yes, yes, my lord.
LCR received.
Yes, my lord.
None appears for the petitioner.
Kindly pass over for the time being.
Yeah, please, okay. FLS come for the first time, Lordship. I am appearing as legal aid counsel. Lordship, appellant was convicted under section 304, part 2, Lordship. Lordship will find the judgment at case 9, Lordship. This is his brother, Lordship.
What is the sentence?
A sentence, 7 years, Lordship. Convicting, undergo RI for 7 years and to pay a fine of rupees 5,000.
Yeah, IA is there.
I is there, Lordship. He has already completed, Lordship, half of the term, Lordship. Lordship, we
Third,
take Google, Lordship.
learned counsel for the appellant, legal aid counsel representing the appellant. There is the memo of appeal as well as the impugned judgment and order, the admitted for hearing. Call for the PCR. Please take in on. So had learned additional PP. And as far as IA is concerned, there is an IA.
Lordship, for suspension, Lordship. Aye.
Do you used to file objection, PP?
Lordship.
Want to file objection?
7 years.
7 years, he has undergone half.
More than half, Lordship.
No need to file application.
Okay, I will dispose of later on. Chamber, right.
Lordship, my name may be reflected, Lordship. Hey, Google,
Lordship,
Lordship.
I have said we have Lordship on that, after receiving the TCR, Lordship, then Lordship can dispose of the IA, Lordship.
After receiving case diary.
Already three and years, 6 months, already last post.
Then we can
7 years
submit-
total punishment.
then we can submit something going to the TCR, Lordship, otherwise. Then we can submit ourselves, Lordship, from going to the TCR, Lordship. On that day, Lordship, we can consider IA, Lordship.
But you said it can be
Objection.
disposed of.
Not it, but they.
We have said we'll dispose, then
Lordship,
after that you have made your submission. We'll record something of yours.
Deplorable.
Show the name of Mr.
Hey, Google, Lordship. Legal aid.
Gogoi in the cause list.
Deplorable.
Very settled, my lord. The amount is paid as per, the amount is paid in the here, I am for the complainant, the NI Act, the check amount was 4 lakh.
Yes, last time you short time till Friday to pay. What happened? Paid.
Paid.
Now?
A revision may be allowed, man.
Hmm?
Revision may be allowed because the amount is paid. There is
On compromise,
compromise out of
judgment may be set aside.
There was a imprisonment for 6 months, simple imprisonment, and 6 lakh was the compensation.
Then there is no purpose for this revision, I mean.
Yes.
It is submitted by learned counsel for both the parties that the amount in question has been paid by the
On compromise, my lord, by the accused petitioner.
by the accused petitioner to the respondent, sole respondent,
Respondent complainant.
as per compromise agreement, and hence no cause survives for adjudication. Accordingly, the instant revision stands closed.
Well, consequently, my judgment may be set aside.
My lord, the judgment should be set aside, my lord, because otherwise.
Yes, impugned judgment dated.
My lord, judgment dated, my lord, 6/3/2025, my lord. Passed by the learned additional session judge Hailakandi in criminal appeal number 6 of 2025, affirming the impugned judgment and order dated 30/12/2023, passed by the learned additional chief judicial magistrate Hailakandi in NI case number 61 of 2029 under 2019 under section 138 of NIA.
Is set aside in cost.
Criminal appeal of 6 of 24.
For 6 of
24. How like that?
Diploma.
May I please, your lordship? Lordship, this is, my lordship here, this is a case in which I have come against the final order, my lordship, with regard to maintenance, my lordship.
It was a deal last time. modify করে দিলে করবো। Yes.
Final order with regard to the granting of maintenance, my lordship. Lordship, the respondent is the stepmother of the petitioners, my lordship. Lordship, the father of the petitioners has married thrice, my lordship. Petitioners are the sons of the first wife and the second wife, my lordship. The first wife is also alive, the second wife is also alive, my lordship. So the Honorable Court has granted maintenance with regard to a petition filed by the stepmother, granting maintenance of rupees 8,000 with regard to the respondent first party and the two minor step sisters. This is daughters of the respondent, my lordship. My lordship, my lordship, this matter, while at the time of filing of the petition, my lordship, there was no execution petition. And during the pendency of this petition, my lordship, an execution petition has filed, my lordship. So, my lordship, I have filed an additional affidavit with regard to the stay of the execution till the disposal of this petition, my lordship. My grounds for that is that, my lordship, during the trial, my lordship, there were 4 PWs and 4 DWs examined, my lordship. And amongst the respondent herself, in her deposition has stated, during that period, after the death of the father, my lordship, out of total 21 bighas of land, my lordship, the land was equally distributed among the 3 wives, among the sons. She got her share of 3 bighas, my lordship. Amongst the 3 bighas, she has sold some, and some are in her possession. And during her deposition, she has also stated clearly that all the crops of cultivation she used to bring to her parental house, my lordship. And there was also an amount, my lordship, total amount during after the death of the father, my lordship, there was a Sukti Patra done, and out of which, my lordship, 4 lakhs was given to construct a house and 1,50,000 was given to the respondent for the maintenance of the 2 stepsisters, my lordship. The petitioners are also living after day to mouth. They are living in kacha houses. They are daily waste, my lordship. For them, this amount is very high. And at that point of time, when the father expired, my lordship, everything was done and every consideration was made. And even the landed properties were also equally distributed. And if I take my lordship to her evidence, if my lordship wants to see the evidence at page evidence of BW. My lordship, 191 mil. My lordship. 168, my lordship. One, 168 is the evidence on affidavit, my lordship, and the cross is at, my lordship, 174. Right. Read, my lordship. I read, my lordship.
Yes.
I do not know the contents of my evidence on affidavit. My age is not 36 years. I'm 26 years old. I am the stepmother of the second party. Second party name Fojul, mother's name is Pulesa. Second party, namely Jaru's mother's name is Zaleka. Jaru has 3 children, his wife and his mother. The daughter of Jaru got married and the rest children are school going. Jaru is responsible to maintain his family. This is the petitioner, my lordship. Next, my lordship, Habibur Rahman has 2 children and his wife. Mojibur Rahman has 2 children and his wife. Fojul has 2 daughters, 1 younger sister, wife and mother. All the second parties are residing in separate houses. It is a fact that during the lifetime of my deceased husband, he was harvesting crops. My lordship, this is very important. Harvesting crops on my land. After the death of my husband, the second parties gave me 3 bighas of land out of 13 bighas in total. My lordship, total. I have sold 1 bighas of land from the 3 bighas of land, and I sold the same to the second party, namely Habibur Rahman and Mujibur Rahman, for a sum of 2,70,000. I have sold the said land on the basis of unregistered deed, and the second party, namely Habibur and Mujibur Rahman, are cultivating at the said land for their livelihood. I am cultivating on my 2 bighas of land, my lordship. It is not a fact that after getting the plot of land, after 2 days of the death of my husband, I went to my parental house along with my daughters. My lordship, I bring all the crops of my cultivation to my parental house. Then the aftermath. It is a fact that during the month of Ahar, I used my land for cultivation of rice, and it is not a fact that after season of rice cultivation, I used the same for cultivation of vegetables, for which I received sufficient money for my livelihood. My lordship, I know Alauddin, who borrowed a sum of rupees 1,40,000 from my deceased husband. After 4 years of the death of my husband, Alauddin returned the money to me. What happened was that, my lordship, in the records, there are the father has borrowed lots of money from different persons. After his death, those persons came to the petitioners. Petitioners were continuously returning those money. And one of the person named Alauddin, my lordship, he has paid 1,40,000 after 4 years of the death of the husband to the respondent, my lordship, which he has also admitted, my lordship. So, my lordship, the next, it is a fact that during the lifetime of my deceased husband, he mortgaged about 20 bighas of land to others for his treatment, and he redeemed the same before his death, my lordship. My lordship, this is a case, my lordship, where the respondent, my lordship, was given equal share. She was given even the money also, as per their capacity, my lordship. And these petitioners are also living hand to mouth, my lordship. They are ways on us. And even, my lordship, it is also been admitted in one of the deposition, my lordship. If my lordship be pleased to peruse page 180 for a second, my lordship. 180, I take your lordship only to the relevant portion. It is one of the, during cross-examination of one of the PWs, my lordship, in the 7th line. All the second parties are living in kacha houses. This reflects the capacity also, my lordship. So, my lordship, this is a case, my lordship, where the Honorable Court was pleased to grant maintenance to the respondent and to the 2 minor daughters, my lordship, of rupees 8,000, where the petitioners, all the children of the petitioners are also minor, and the mother is also alive. The first wife is also alive, the second wife is also alive. They are living with the petitioners, my lordship, and they are minors. They live in kacha house, my lordship, and my lordship, they have their own minor children, all school-going minor children. So, my lordship, at this stage, my lordship, if wants to hear the matter in length, my lordship, in this case, I pray for the stay of the execution, my lordship. And my lordship, if wants to hear the matter today itself, I'm also ready with that also, my lordship. Lordship, this is a fit case where my lordship would be pleased to interfere, my lordship, because all were granted their own share. And my lordship, she has admitted out of 3 bighas, she has sold some, she got money for that. Other part, she is doing cultivation of land. My lordship, if someone gets land, someone sells the land, and someone cultivates the land, it does not give the right to the other to ask for the other's land, because her part of share she sold. She got remuneration for that. Half of the part she has been doing cultivation, she has admitted that all the crops of cultivation she used to take to her home, my lordship. So, my lordship, I pray for.
Yes, respondent.
My lord, this is not a civil suit, lordship. My lord, the question of maintenance is there, my lord, social, my lord, justice, lordship is involved in this case, lordship. Now, page 168, my lord, her evidence, lordship, it is clear that she was driven away from her home, lordship, and she was compelled to take shelter at her, my lord, paternal home, lordship. My lord, entire property is, my lord, grabbed by the, my lord, the respondents, lordship.
But
My
the
lord, only the
cross-examination reveals otherwise.
lordship.
The
Only the
cross-examination reveals otherwise. It seems that she has got land out of 1/3 of the land she has sold. She is cultivating the other land. She is getting income from that. What?
purchased by the respondents, lordship. Now, question of survival is there, my lord, minor daughters.
If you sell it, then what is to be done?
My lord. So not a single pie has been paid, lordship.
You get all the property, then you sell it and say, I have no money, now give me more.
Now, my lord, children, what about children, lordship?
No, that's, you should have thought about that. Why did you say?
My
Why?
lord, children, they are school-going children, my lord.
What did you do with the money you got out of the land?
My lord, school-going children, lordship. And she was, my lord, driven away, lordship. My lord, at the time of marriage, 3 bighas land was given, lordship. This was not given by the respondents lordship. Only question is, my lord, 4 persons lordship, 4 respondents, my lord, per head, my lord, 2,000, my lord, directed to pay. My lord, rupees 500 for each of the side lordship, and 1,000 for, my lord, the my lord, mother lordship. This is for 4 persons lordship, 2,000 per month, my lord, is payable by each of the respondents lordship. This is not a single pie has been paid to the petitioners lordship.
2000.
Even execution is filed lordship.
Lordship,
Even after 7 months, my lord, they are so adamant, my lord, they will not pay.
my lordship, 2000 may be small for some person, but 2000 may be very important for some person, my lordship.
Right, they have personal vehicle lordship, personal private cars, my lord, my lord, fair price shops lordship, landed for 30 bighas of lands, my lord, they are occupying lordship.
Evidence. You have to go by evidence, my lordship, in cross examination.
We have stated in the petition, application lordship. Anet, my lord, code below has, my lord, rightly, my lord, stated, my lord, everything observed lordship.
What?
Many things have been considered lordship.
My lord,
Let us fix a date of hearing then,
It may be fixed, my lord, it
shortly.
may not be stayed lordship.
My lordship,
Execution
execution process-
case is pending lordship.
my lordship, execution may be stay, my lordship, a date may be fixed, even if it is taken today, my lordship, I'm ready, my lordship. A date
You
for,
are defying the order of the code below, my lord. In such a situation, my lord, interim protection may not be, my lord, granted lordship.
My
At least
lordship,
one amount, some amount ought to have been
I
paid.
take your
lordship.
lordship to
Nothing.
phase 188.
7 months, my lord. After 7 months, my lord,
188 for
clear
a
for,
second,
my
my
lord,
lordship. Phase 188.
day of
for
the
a second.
proceeding is, my lord, execution is, my lord, placed before your lordship.
My lordship, I take your lordship to 188 for a second. It is PW3.
Where is the PW3 is crossing, where is that?
Yes, my lordship, 188.
188.
88, PW3. Examination of PW4, my lordship, 188. My lordship, once the cross examination PW3. My lordship, PW4, 188. Though it is written cross examination PW3 down below, up it is written PW4. My lordship, the 7 line. It is a fact that the first party went to her paternal house after getting her share from the second parties with all her belongings. It is their prosecution witness, my lordship. He is the former Gaon-Bura, my lordship. Her prosecution witness, he has stated, it is a fact that the first party went to her paternal house after getting her share from the second parties with all her belongings. My lordship, if for a second take 189 also, my lordship, the first, second, third, fourth, fifth paragraph. It is a fact that the husband of the first party had mortgaged most of his landed properties and the same was redeemed by the second parties. At 189 fifth paragraph, my lordship. Even my lordship, it takes 189 second paragraph also. It is a fact that Muhammad Alauddin borrowed a sum of rupees 1,40,000 from the husband of the first party, but the same was returned to the first party after the death of her husband, my lordship. 189. She got all her money, all her properties, every share, my lordship. And my lordship, it was her prosecution witness. But the Gaon-Bura.
Yes, just on the interim, PW3 stated that your income is 2 lakh rupees per month, but there is no denial in the cross examination. So we'll fix a date for hearing.
My lordship.
Yes, give a agreed date. এইটো complete আছে জানো হেৰিটো
My lordship, I have seen, it's not complete even. I have,
All the orders কেইটামানে আছে বেলেগতো একো নাই দেখোন ইয়াত। বাকী বাকীখিনি
my lordship, it's not complete. I have seen.
একো নাই বেলেগ দেখোন এইখিনি এই বস্তু But you have given all the
Yes,
evidence
that's
there.
translated also. No, my lordship, the Shruti Patras were in handwritten, so we could not get the certified copies. Those are in record, my lordship.
Those are my lord, unregistered documents.
No,
lordship.
whatever, my lordship, these were exhibits in
Not
record
proper.
because, my lordship.
No, here on the limited question is whether we'll
Yes,
proceed with the hearing on the basis of this or do we need the
My lordship, up to my lordship, because I have translated everything, only those Shruti Patras, because those
All
certified
right.
copies I could not receive.
as agreed to by learned counsel for both the sides list the matter for hearing on
My lordship, with regard to interim, my lordship, execution, my lordship, with regard to interim, my lordship.
No, that is why we are giving a fixed date for hearing. We are not considering the interim now.
Next date is fixed. My lordship, then prior to that,
Obliged, lordship.
11 February is the date, my lordship. Then my lordship on first week of February.
11 maybe the date you file an application there saying it is fixed for final hearing.
Because we gave my lordship, to be very fair enough, we gave application thrice, my lordship, because they came up with saying they did not receive the copy once, though we have served dusty, my lordship, and then register post also. That way 2 days gone, and we will not get any chance, my lordship, in trial court also.
Obliged, lordship.
Lordship, can it be in first week of February in that
All right.
My lord, an amount may be my lord directed to be paid, lordship.
hearing? Could you do first? week of
Maintenance
February?
order is there, lordship.
Yeah, if you want on first week of February, have it on first week of February. What is the difficulty?
First week of February, হব আপনার, হ্যাঁ?
Last week আহিলে ইমান ডাঙৰ petition বনাইছে চাবতো লাগিব ন
My lordship,
they have enough money, lordship. So voluminous
my
petition
lordship,
is
what,
there.
what kind of submission? We have to annex every document to the court, my lordship.
They have, my lord, personal cars, my lord, the fair by shops, landed 30 acres of landed property. What the ego is that they will not pay.
My lordship, the
This is
question,
the point.
my lordship.
You are also not doing the you are also not doing the case pro bono.
My lordship, can, that are first of week of February.
Obliged, lordship.
First week-
My lord,
Huh?
February, last of
Second-
February, maybe last of May. I'll have.
Last February, did you? Thursday, sir? Oh, my lordship on 5th February. 5th February.
Call for lordship.
If you are not agreed, then we'll pass our own orders.
TCR লাগে যদি কওক আপুনি তেতিয়া।
My lord, first of February, my lord.
When do you want?
3rd February.
When do you want?
Today is 28 lordship.
When do you want?
At least last of February, my lord, I'll take some preparation, my lord, I have to some.
Is the matter on? Yes, give the date.
Obliged, lordship.
It is submitted that the next date before the learned trial court is fixed on
11 February.
11 February, provided that no coercive action will be taken against the petitioner on that date.
Obliged, my lordship, highly obliged.
So I apologize, I was not here, Miller, when the matter was called.
Some instruction.
Yes, sir. Instruction was called for whether charge sheet was filed or not. Otherwise, my lord, going by 187, my lord, it 60 days, my lord.
Where is the FIR?
FIR, my lord, it pays 16, my lord.
Oh, that
Yes, my lord, that
fake doctor.
fake doctor.
After some time, nursing, we are conducting, they said not
Hmm?
yet come, nursing, that report is not yet come.
Then that two, my lord. Oh. For something. All in.
Okay.
May I please your lordship? Case diary was called for, probably case diary is received, lordship.
We have received the series also.
Lordship, lordship will find the FIR on page from page number 8, lordship. Lordship, the allegation is, basic allegation is, lordship, some FIC on notes were recovered. Total amount of 7,290 notes were recovered, Lordship. And Lordship, as of all the offences, the allegation that are corroborated are 90 days offence, Lordship. And as of today, 74 days petitioners were in custody, Lordship. And Lordship, I'm not on merit, Lordship. Lordship, kindly investigation might have proceeded substantially. On progress of investigation and length of detention, Lordship, my prayer is limited prayer, Lordship, on length of detention, Lordship. And they have been thoroughly interrogated. They were taken into police custody for 3 days, Lordship. After proper interrogation, they have been forwarded to judicial custody. And now they are in judicial custody since 1911. Would be 74, Lordship. 90 days offence, Lordship. One lady and
Any report is there, FSL report?
FSL report awaited, Lordship. And apart from that, Lordship, this is not only 7,290 rupees, Lordship. This is, Lordship, 36,45,000 rupees, Lordship. Notes are there, Lordship. 500 rupees notes are also, that is 7,290 numbers of note of 500 rupees, Lordship. So, Lordship, here in this type of cases, Lordship, length of detention, that will not come because, Lordship, this is an offense against the state, Lordship. So, Lordship, get the report till 89 days also. In the meantime, we can file. So let the report be called for. Let the report come also.
Report?
We have to call.
But-
We have already contact the, but it is not received also.
The CD is received, huh?
We have received.
What you have not received?
Report also, that FSL report.
FSL.
Lordship, once the FSL comes, the case will be seated, Lordship, and
He cannot say, he cannot say, Lordship, when
And,
it will be received.
stringent condition may be imposed, Lordship. All the petitioners are local, they are not on flight risks, Lordship. Local person, Lordship. Stringent condition may be imposed, Lordship. Once the FSL comes, the investigating officer can search the matter and they will appear before the trial court.
This is not a run of the mill case, Mr. Counsel. Take notes, you know the ramifications.
Use concepts.
CD is received, but FSL report is not received. Is the matter again on?
So on 9th, Lordship, kindly. 9th of February, Lordship.
10 or 11, Lordship. 10 or 11, Lordship.
Hold.
11 position. 11 good.
On 10th, Lordship. 10th of February, Lordship. Deeply obliged.
Lordship, LCR was called for but has not been received as a.
They are not received, Lordship.
TCR has called for has not been. Scan copy of TCR not received. List again on.
5th or 6th, your Lordship.
All right.
Right.
We have not received the CD, Lordship.
In of this. So that, my lord, can it be 6?
Same order.
6 to
10 তারিখ হলো
my lord, February. It from Hajo, my lord.
9 6 9 Lordship. 9.
All right.
9, my lord, connected matter. Obligable.
Wait, please, my lord. Last order is, my lord, 21, 2026, my lord, kindly.
Yes, Usni. Yes, Usni.
Received. Whether it was communicated.
Lordship, it is on 21, 26, again we have sent the requisition, Lordship. 21, 26.
This order is communicated.
Yes, that order that I.
We have stated to communicate.
My prayer is for interim order, my lord. Section is, my lord, 61 to 3184 and 181 of DNS, my lord.
এটা কমপ্লেন করেছেন স্যার in order to
Right, heard learned counsel for the petitioner. The CD as called for has not been received and order shift reveals that is the sixth occasion on which the IO has failed to produce the case diary. By order dated 20/01/2026, the IO was granted one last chance to produce the case diary on the next date fixed, failing which necessary action will be taken against the IO. It is submitted by learned additional PP that the requisition was sent on 21/1/26.
21/26.
20, okay, 20, on the same day of the last order, that is 20/01/2026. In regard to the same, the IO, who is the IO? We don't know. IO of the case. I shall investigate the case myself. Who is this? Page 15. SI.
Gitanjali Bormon.
Hmm?
SIP Gitanjali Bormon.
Gitanjali Lordship. Gitanjali Burma. He is the informant probably Lordship.
He is the informant.
He is informant.
Yes, yes.
Received and registered Dergaon PSO, and so I will investigate the. I shall
Sir,
take up the
sir.
investigation of the case. Who is this? SI?
Am
P.
Bora.
Borua, huh?
Albert.
Anjal, yeah. Am Borua.
Lordship, this is again an officer in charge Lordship. This is OC Lordship. No, Lordship, right? IO Lordship. IO.
He himself has taken up. SI Pranjal Borua, yes.
Yes, ma'am. Pranjal Borua.
Person and seizure list name is there. The IO of the case, SI Pranjal Borua, is directed to be personally present before this court on the next date fixed. Registry is directed to communicate this order to the Superintendent of Police, Dergaon, as well as OC PS Dergaon, who shall and communicate the same to the IO, SI Pranjal Borua. Is the matter again on next week?
On 9th Lordship. 9th Lordship.
The some
Person appearance has been given Lordship. Person appearance Lordship.
Yes.
the interim TR, my lord, might kindly be. That's 6 months, about 6 times, my lord.
On that day Lordship and decide Lordship. Finally Lordship.
6 times, my lord, CDS, I am suffering. Till then, my lord.
Further, having regard to the fact that the IO has failed to produce the case diary for 6 months,
6 times.
6 occasions, is provided that the petitioner, in the event of his arrest, be released on interim bail of ₹50,000 with one surety of connection with the
Police Golaghat Lordship.
Golaghat.
SP Golaghat.
Okay.
A copy of the order may kindly be furnished to.
Copy of the order furnished to the learned PP.
Blush.
Bail please, your lordship. Hereby petitioner is on interim bail, my lord. He appeared, my lord, and statement has been recorded, my lord, and the concerned mobiles, my lord, there were, my lord, regarding, my lord, non-payments of, my lord, the bill, my lord, of of mobile phones, my lord. They have returned the mobile also before the concerned police station, my lord. They appeared, statement recorded, mobiles are also received. Returned, my lord. Page 8 is the FIR.
This one side.
Mobile to provide. Order copy to থাকিব না?
So have you paid the remainder?
Return the mobile, my lord. It will, case that it might reflect, my lord.
Statement I have not found that is I am searching also.
So the condition was that you have to make the payment of 1,20,000.
Yes, my lord.
What is the value of the mobile?
But, my lord, as per my instruction, my lord, the concerned mobile phones, my lord, he has already, they have taken back the mobile phone, not the money. The case that he will reveal, my lord, whether that is.
But regarding his appearance also, there is nothing also. I will say again also because regarding his appearance, I have not found also. I will take also.
Is there anything regarding return of the mobile or anything in the diary?
I
Check, okay.
Bad blood. Plastic subject in this case. This will be called for.
Yes. What do you want?
This will be called for.
Submitted the CS has already been submitted by CS number.
1/26 dated 8/1/26.
Call for the scanned copy of the TCR along with the CD.
Petitioner is on interim.
26 and 27 arising out of same FIR, Lordship.
CD.
Only in 26.
They did not receive. They did not receive. Please take in on so and so interim to continue.
82 lots.
Lordship, in this case, the petitioner number 2 is on interim, Lordship. This he was called for on the last occasion.
Receive.
We have not received the case drive, Lordship.
Let's say did not receive. Please take in on so and so interim order passed earlier to continue.
19-2.
Please, Lordship, item number 20 and 30 is the same affair, Lordship.
We have not received the case drive.
Lordship, against I pray that interim Lordship, that affair, my lord, if it's found, my lord, then is a first party is a civil nature, your lordship. May I, my lord, police is searching, my lord. So on page 19, my lord, in the affair, my lord. Also, my lord, relation with that my case, my lord. Your lordship.
I am ready to cooperate any in my lord conditions, my lord. I'm a young boy, my lord, and
Hazu Lordship, even a short date Lordship will try to polish the case there.
my lord. 19, my lord. Original FIR, my lord. No specific allegation, my lord. I only refuse, my lord, that month, my. So, my lord, I may be protect my lord till my lord CD, my lord.
Too
come.
serious. Yes, short date.
Lordship. Starting to.
My lord, similar cases fixed on 9, my lord. 9.
All right, 9.
I believe the answer. Address fixed for CD. In item number 31, I am on interim protection, and as per the direction of this honorable court, yesterday I appeared before the IO, and my statement was also recorded.
Yes, counsel.
My lord, CD received, my lord, in item number 31, my lord, there, my lord, that is, my lord, otherwise sufficient materials are there, my lord. He is, my lord.
Saying what?
My lord, 57 numbers of my lord, check books, my lord. Case of money lending, my lord. So, my lord, they used to, my lord, give, my lord, money for, my lord, my lord, 10% interest. And thereafter, my lord, they taken the, my lord, check books and all, my lord. And also, my lord, some kind of signatures, my lord, in, my lord, blank papers with, my lord, revenue, my lord, stamp and all these things, my lord. So, police says the matter, and even, my lord, they use, my lord, muscles power and all these things. So that is going on. Independent witness also in there, my lord, their statement, my lord, reveal these things, my lord, how they have taken. And my lord, that is item 32, my lord, is the.
But whatever you say or allege or say that
My lord.
materials are present, those relate to the offenses which are bailable.
My lord, here, my
Only
lord,
non-bailable
sections are,
offenses,
my
I
lord,
think.
111 2B, my lord.
Yes.
That is for, my lord, 90 days offense, my lord.
Yes, yes.
111 2B, my lord.
Yes,
Yes.
that is with regard to economic offense.
Economic offense.
So but you were saying muscle power, then
My lord,
keeping up
they
all
stated,
these are.
they stated, my lord. And
Yes, but
regarding
those
that-
relate to bailable offenses. That is
My-
why other sections are also there.
other section, my lord, in the Caesar, my lord, that is a different, my lord, people's, my lord, sex, my lord. I don't know, kindly produce the Caesar list. Otherwise, my lord, the 32 is the son of the, my lord, that is the petitioner number in 31, my lord. He was already arrested and, my lord, already
Okay, last
completed
64
64 days.
Today is 64 days.
days, my lord. In that case.
Considering the length of detention, my lord, and
Right, item 31. 27, 120. CDS called for has been pursuant to interim protection granted by this court by order dated 27/1/26. The petitioner has appeared before the IO and his statement has been recorded. Para learned additional people submits.
My lord, regarding, my lord, his, my lord, recording of the statement, my lord, that is not available with us because, my lord, CD is, my lord, available up to 26/12/2025.
By learned counsel. That there are incriminating materials against the large number of checkbooks, bank pages with revenue ticket signatures, ATM cards, till stamp paper, etc. were recovered. The house of the where I have perused the CD. Therefrom, does not appear prima facie that 111 within bracket 2 pertaining to organized crime involving economic of attracted rest of the available this of course is a prima facie view and shall not have any bearing on the trial if one commences. Having regard to the above, as well as the submissions of learned counsel for the petitioner reflected herein above, therefore pre-arrest bail is the order of interim pre-arrest bail dated 26 is by made up. Order provided that trial shall not try to influence or intimidate in any manner. What is against the son?
Against the son, my lord, both are my lord, though he is not FIR name, my lord. Allegation is similar, my lord. He is already 64 days today. Both father and son, my lord.
Regular bail having regard to the period of detention of 64. Add kori dile hob. Emon eke থাকিব।
To the satisfaction of CJM Borpeta.
দিয়া আছে তার প্রশ্ন।
Published.
As per I lordship, he did not hand it over the his two phones number lordship, only his personal keypad phone number he has submitted, and that money 1,20,000 that he has not returned lordship.
But this is my instruction, my lord. He has handed over the mobile phone, my lord.
Then he should have obtained a receipt.
But if there is iOS note, my lord,
That is, I have seized one light blue color keypad mobile phones from Sridhar, and there is a specific note that says, as per direction of this honorable court, and that amount has not been given. That is the main condition also.
But whether I
Prepaid mobile phone means those earlier one that
earlier one. APR হয়েছিল না এটা?
APR হলে হেতু ফোন দিছে। APR হলে the condition was not fulfilled.
But my lord, let me take instruction for my lord.
condition is clear. Your instructions may be wrong.
But my lord, let me take an instruction on Monday or Tuesday, my lord.
CD has been received. Narrate counsel for the petitioner seeks some time to obtain proper instructions from the petitioner. Hence, list the matter again on.
Oblige your lordship.
Will retain the CD lordship.
CD be retained.
And interim order may continue till Monday.
First earlier to continue till that date.
Oblige your lordship.
None appears from the petitioner side, Lordship. Ichi.
His name is. This case was for last listed on 8/1/2021. Today on call, none appears for the petitioner, although the name of learned counsel, Mr. S.S. Sharma, has been shown in the cause list. That is the. Under the aforesaid circumstances, issue court notice to the petitioner as well as the. Okay, respondent number 2 will not do it now. Registry is directed to take necessary steps in this regard. Place the matter again on.
May it please, your Lordship. Number 35, Lordship.
Yes.
In 15 meter, Lordship, kindly the meter may be fixed during Lordship.
Learned counsel for the petitioner. It appears that the paper book is ready. The already admitted.
Is in bail, Lordship. Lordship.
But is it admitted?
Admitted.
Is the matter for hearing? You get it.
Obliged.
Five to the একেলগে আছে অর্ডার পাস করব লাগবে না নাই $35 ওর নাকি 34 লিখে দিবেন না বলি বাকি কি হবে হ্যাঁ। পেপার বুকটো কিহৰ এটা to 35 লিখিবা হা 5 or 15 Yes, 36.
Wait, please, Your Lordship. Lordship, in this matter, some instructions are required to be taken from side as the order passed by the trial court was challenged regarding the Sridhan articles of the petitioner, Your Lordship. So, some time, 2 weeks time may be given, Your Lordship.
But have you taken steps for service on respondent? This was the last order. Learned counsel for the petitioner. This case was last listed on 18/2/22. Which date the petitioner was directed that notice be issued to the respondents afresh through OC concerned as well as by Dusty. Petitioner was directed to take steps within 3 days. However, since the case has been said for more than 4 years, it is once again directed that case be issued to all the respondents afresh through the OC concerned as well as by Dusty. Petitioner to take steps within 3 days and file affidavit accordingly. List the matter again on 2 weeks or episode did ya?
Apply challenge.
My pleasure. Matter arose out of a case under Negotiable Instruments Act for dishonor of check. So the petitioner has instructed me that he wants to settle it out of court, and for that some time may be granted. He is trying to initiate talks with the respondent.
What is the amount?
The compensation amount is 20 lakhs.
20. Petitioner, in fact, is not a revision of the appellate order. Appeal has been filed and it is pending. This petition challenged this validity of the direction to pay 20% of the fine amount subject of the petition. However, since the petitioner is willing to try to settle it out of court, kindly some time may be given. 1 month or
My lord, if it is reflected that they are willing to settle the matter, then I have no objection to time being given. Just a
course.
date may be fixed, my lord, because
Counsel for the petitioner submits that the petitioner is willing to settle the matter and accordingly prays for 1 month's time. And counsel for the respondent does not object to the same. Hence list the matter again on
Can it be, my lord, towards the end of February, 28th February, if possible? 27th February.
which date?
27th February.
Grateful.
LCR is received, Lordship.
Anybody for respondent number 2? This case was last listed on 6/11/2017, wherein appellant was directed to take fresh steps. Service of notice upon the respondent number 2.
Lordship, that step was taken, Lordship. Step was taken, Lordship. The serial
Since
number
the matter has been listed after about 7 years, petitioner is once again directed to take fresh steps upon the respondent number 2 by registered post with AD with period of 3 days from today. Additionally, steps taken through concerned OC and also by way of dusty service.
Dusty may be prohibited, Lordship, because the address of the, because the informant,
Website may, you may if you can.
because he is married and the petitioner does not know the location of
All right, forget the dusty service. Is the matter again on? A date, fix date.
Pleasure. Please, Your Lordship. As per office note, my lord, service awaited 2011-2085, my lord. An appeal, my lord, under section 76. This need to be served, my lord.
When did you last take steps?
We'll take fresh steps, my lord. Month of 2025, my lord.
This matter was last listed on 12/7/17. এখানে একেই দিয়ে দিবেন। List the matter again on.
Lawless.
Your Lordship, no cases registered against the petitioner in Delhi.
On the basis of that, my lord, they are calling and harassing the petitioner, my lord.
No case, Lordship.
There is no case and they are harassing you, lodge a complaint with the
On the basis
commissioner
of
of
the
police.
idiot matter, my lord. And they're forced to pay the money, my lord, of 40,000. I have especially stated, my lord, in para 5, my lord, pays 4, my lord. In the police station, she paid that money, my lord. My lord, dispose the matter with the observation.
Granted additional PP upon instructions received has submitted that no FIR has been registered against the present petitioner at which police station?
Tezpur police station.
At Tezpur police station.
PD number is 16 of it.
However, it is submitted by learned counsel for the petitioner that the petitioner is being harassed on the basis of GD entry number 16, Tezpur Police Station, GD entry number 16 dated 3/12/2025. Full stop. The instant application is disposed of with the direction that the petitioner
May I submit, Lordship? May I submit? Only GD entry has been done, and in that case, Lordship, IO may investigate, may call her for investigation purpose, Lordship. And in that case, any interim protection that may hamper the interrogation also, Lordship, because Lordship, after getting that such any protection.
What is the date of the GD entry?
3/12, my lord.
3/12.
My lord, he can issue a notice, my lord, at any point of time.
Lordship,
There is no bar, my lord.
If any
Why
case
she
is
is,
registered, then also they can
Directed
come,
that
Lordship.
disposed of
Six
with the
lady, my lord.
direction that the police shall not harass the petitioner merely on the basis of the aforesaid GD entry. However, it would be open for the IO to take necessary steps as provided under the provisions of the PNSS. This is a civil offense, 35 offense. He can issue notice,
Issue notice, my lord. That is why they are working like a recovery agent, my lord.
including issuance of notice under section 35 thereof. Petition stands disposed of accordingly.
So for under what section that case will go, Lordship? It is
But-
their statement that they are.
No,
only
we
for
went to
that-
the police station, my lord.
may
That is
go
why
to
we
many
get-
other extent, Lordship.
That is why we said may,
Yes,
as
my
per
lord.
provisions of BNS.
That is section had notice, but that notice part may not. if not-
As per law is there, my lord.
Because Lordship, if on the basis of GD&T, they may not harass, Lordship. That's
Ah,
what
that's
is
it.
clear.
But that will prevent them from calling or anything. That is why we have said,
They can
if
issue
in
notice, my
fact
lord.
some offense is there,
Definitely.
if we say not be arrested, then they will just stop.
My lord, at least they should issue notice, my lord.
This is appeal against acquittal, my lord. Service is complete. Opposite party has already appeared and LCR also received. So Lordship may fix it for hearing, my lord.
LCR has been received and the party has also entered appearance. Hence, there is admitted for hearing. Is the matter for hearing on
Obliged.
On appears.
none appears for the petitioner. This matter was last listed on 21/05/2020. Due to long lapse of 5 years since then, petitioner is directed to take steps for service of notice on respondent number 2 by registered post. Okay, its name is shown. Are they still in circulation?
Name is Sony here.
Yes, but are they still here? Somebody may have also left the profession. We don't know. Follow registered post with AD within 3 days. Is the matter again on TCR আহিছিল
41.
নে? TCR নহয় যেন পাইছো এইটো। TCR আগতটোত লিখিব TCR has also not been received. Issue reminder. Yes.
As per the last order, we are directed to take fresh steps on respondent number 2. On 9/4/8/25, we took steps and it came answer on 9/12/25. The reason is insufficient address. As per us, the last known address of the respondent number 2 is given as per the petition. Oh Lord, Your Lordship may direct us service of notice to jurisdictional police station. In the meantime, we will search for the substitute address of the respondent number 2.
Is submitted by learned counsel for the petitioner that although steps were taken on the respondent number 2, the same have been returned, notice has been returned unserved due to insufficient address. Hence, since this is an whole pending matter, steps be taken through the concerned police station, through the registry. In the meantime, petitioner shall also collect the present address of the respondent number 2. List the matter again on.
Much obliged, Your Lordship.
That please, your lordship. Lordship, in this matter, the TCR was called for, lordship. Perhaps the TCR has not been received yet.
Respondent number 2, you are appearing. As per office note, TCR has not been received. Registry is directed to issue reminder. Learned counsel has entered appearance for the respondent number 2. List the matter again on.
Problems.
Please, your lords. And this matter was sent to the mediators from that both parties have failed to settle this matter amicably. As otherwise, his service is complete, my lord. The fixed for hearing.
It was sent for mediation.
Yes.
Failed.
Failed.
No report is received back.
There's a report, my lord, the one. Yes. I've seen this. The date is fixed for
Learned counsel for the petitioner and learned counsel for the rest. For communication of Secretary High Court Mediation Center dated 12/11/25. Mediation has remained unresolved despite 6 numbers of sittings. Case is required to be heard on merits. The parties have appeared. TCR is there.
That's what according to the LCR is there.
Huh?
LCR is there.
Is the matter for hearing. on
As usual, person.
17 March.
none appears from the, for the petitioner. This is an application for condonation of delay in preferring the connected criminal revision petition. By order dated 3/3/2025, petitioner was said to take fresh steps, but as per office note, no steps have been taken by the petitioner. The instant application is dismissed for
May I please, Your Lordship. Your Lordship, office note indicates that service has been completed on R2, Your Lordship.
R2 appears.
On behalf of the amicus, Your Lordship.
As per office note, service report on respondent number 2 has been received back, but none appears. Was as us to represent the respondent number 2. The TCR as called for has not been received. Registry to issue reminder. Matter again on
Your Lordship, a copy may be served.
half copy of the petition upon the amicus.
Right,
By
Your
3
Lordship.
days from today.
Lordship, the matter may be timing for the, possible for the timing, Your Lordship. There is laying in another code, Your Lordship.
Your Lordship, even the legal aid counsel also representing the respondent number 2 is on. Another date may be fixed, Your
No,
Lordship.
no, Your
Yes.
Lordship,
It's fixed on the 21st of January, Your Lordship.
Lordship, it is about 7 months, Your Lordship. The accused is in jail, Your Lordship, and his father is bedridden, Your Lordship. Therefore, there is some urgency, Your Lordship. The matter may be kindly taken up at 2, Your Lordship.
Is there any IA?
Yes, Your Lordship, for bail, suspension of the judgment, Your Lordship.
What is the sentence?
10 years punishment, Your Lordship. POCSO code, Your Lordship.
Right after some time.
May it please your lordship, in this case, we are convicted under section 304 part 2 and 34 and sentenced for 7 years and fine of rupees 1,000 in default to simple imprisonment of 3 months, your lordship. I'm praying your lordship that the respondent number has appeared, 2 years appeared, your lordship. We have name is also shown, your lordship. Respondent number.
Now,
I'm only praying for suspension of sentence, your lordship, at this stage. And they may be allowed to go on bail. All along, throughout the trial, they have been appearing regularly, your lordship. I'm only praying that they may be allowed to go on bail, your lordship.
One year, sir.
91 days, your lordship. 91 days today, till today, your lordship. 7 years conviction.
7 years.
Sentence.
Chambers.
Deep level.
Your Lordship, we have not taken the instruction that charge sheet is pending because of the not recipient of not receipt of FSL report. But the offence is 90 days offence it is, Lordship. Culpable homicide not amounting to murder, Lordship, imprisonment for life.
No, my lord, may I submit, my lord? 304, earlier 304 section IPC, my lord, and now 105. There are difference, my lord. In 301, 304, my lord, it was 3 categories was defined, my lord. But in 105, my lord, kindly see, my lord, 105. There is a clear distinction, my lord, without having no intention, my lord. If it is no intention, then 5 years up to 10 years. Up to 10 years, my
But
lord.
main portion of the section also, whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life.
No,
Or imprisonment as a description for term which shall not be less than 5 years, but which may extend to 10 years.
Exactly. So 5 years when there is no intention, my lord. So what 304, earlier 304 has been, my lord, reduced, my lord. It has been, it has been brought to a very narrow compass, my lord. But now, my lord, 5 years up to 10 years. If it is 5 years up to 10 years, then, my lord, 187(3) of the BNSS will apply, my lord. One 187(3), my lord, says. May I read, my lord? 187. It says, my lord, the magistrate may authorize detention of the accused person beyond the period of 15 days if he is satisfied that adequate grounds exist for doing so, but no magistrate shall authorize the detention of the accused person in custody under the subsection for a total period exceeding 90 days where the investigation relates to an offence punishable with death, imprisonment for life, imprisonment for a term of 10 years or more. Of 10 years, my lord. But here in this case, 105, it says 5 years up to 10 years. So in that sense, my lord, 60 days will apply. To
In
my-
the forwarding lordship also, it is stated evidences has been found regarding many other victims in the case, as the accused has been cheating multiple people over a long period of his personal gain.
First, let us get over this statutory bar period question.
Well, and prima facie, my lord, from the materials, it suggests, my lord, he was a, my lord, let us forget about whether he's a, my lord, fake doctor or a genuine doctor, my lord. Whatever, my lord, he was brought back. He was brought to the residence of the informant, my lord, and he was asked to, my lord, treat the victim, my lord. And he refused to push injection, my lord. I don't know how they found empty vials of the injection, my lord, there. So it is a cooked up story, my lord.
But according to the FIR, it was clear that he has.
FIR was lost after 2 days.
After
Fairly
administering
civil.
the injection, the lady was died.
Incident happened on 25th, my lord. FIR was lost on 27th.
So 167 or 187, 90 days, that has been interpreted by the Supreme Court to mean that the minimum punishment must be 10
Yes,
years.
Yes.
Yes.
But here, may go up to imprisonment for life, but the question is of the minimum.
That is also
Instead of
clarified.
10 years, it says it's less than 5 years.
Yes, my lord. Without
Not less than 5 years.
Earlier it was 10.
Just 10.
Yes.
Now it is 5.
Yes. That is a distinction, my lord. And it has been also, my lord, clarified in Kesar Singh and others, my lord. There is his husband.
Yes. Which case?
Yes. Kesar Singh.
Kesar Singh and others, my lord. Decided on, my lord, 29/4/2008 by Supreme Court, my lord. My lord, I'm sorry, but it is a little bit unarranged, my lord, because of the printer setting, my lord.
Regard to what?
This was regarding, my lord, earlier 304, when, my lord, is
This
attracted.
is of 2008. How can you
Yes,
look?
prior to that. The earlier IPC section, my lord, 304. But in BNS, my lord, it has been simplified, my lord. So 5 years has been put in, my lord.
There is 63 days, my lord, he is behind bar, my lord.
Pick up the law.
Follow.
None appears from the prisoner side also.
None appears for the petitioner. For your respondent number 2, present. You have been served copy.
Copy of the petition. For this IA, I don't have the copy.
Submitted by learned counsel for respondent number 2, that copy of I has not been furnished to him. Or is directed to furnish the same within 3 days. Is the matter again on?
My lord, this is a criminal appeal with 68 days of delay, my lord. So he is behind bar since the judgment and he has only his mother. So the delay happened, my lord. So may I pray to condone the delay and thereafter, my lord, let the appeal be fixed for admission. Paragraph number 8 onward, my lord, my explanation is there.
You heard learned counsel for the petitioner. Appellant. You heard learned additional PP. An application for condonation of delay of 68 days in filing the connected appeal against the judgment. Judgment and order of conviction. Sentence passed by the learned, which brought
Session Judge Soradio, Sonari.
Just Soradio. Sessions case number 62 of 2021.
Yes.
Stated that para 9, 10, 11. Where the aforesaid averments are supported by an affidavit. Consideration of the same. I am of the view that the applicant has sufficient grounds for condonation of the delay. 8 days. Accordingly, condone. I stands disposed of. Register the connected criminal appeal and
Right.
Yeah, please, Your Lordship. Well, this criminal revision petition, my lord, is directed against the impugned criminal proceeding, my lord. That has been.
Respondent has appeared.
But as per office note dated 28 January, my lord, 26. That service report is awaited against respondent number 2. That is the victim, my lord.
Earlier also it was,
My lord, yes.
maybe you
Now,
should
my
take
lord,
fresh steps.
Now, my lord, district it notice was issued through district magistrate Tinshukia, my lord. On 13/10/25.
But as per office note dated 28/1/26, service report in respect of respondent number 2 has not been given back. Which was issued through the district magistrate Tinsukia. 13/10/2025 by the registry. Registry to issue reminder. Await service, place the matter again on.
I'm obliged, my lord.
Yes, Mr. Sharma, we are.
My lord, here the lady was convicted for 10 years under the NDPS Act, my lord. My lord, the lordship might have gone, last time my lordship had gone through the brief and asked them whether they were compliance of section 42 and 52 of the NDPS Act, my lord. That was not at all complied, man. Not only that, but the seizure was not proved at all. The seizure witnesses said, no, we have not seen what was seized. Even the IO says, I don't know. I found the material open in my office. How she was convicted, my lord, without any material?
All right, we'll take up.
At 2, my lord.
Number 1.
Revision is dismissed.
May I please, lordship, my lord? The appellant was mal convicted for 10 years on the ground of possessing small amount of alleged drug. And but you also can see the evidence part, and I'll take a lawsuit directly to the evidence part. PW1. These are witnesses. PW Manor, Utpal Rajkumar. English translation, no? Translation. उसे एक से नहीं पाऊं. 2 से 1 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 से नहीं पाऊ Indicting to Crossroad Marriott. Hotel খনত যেতিয়া তেতিয়া আৰু
কাষ্টমাৰ আছিল
কাষ্টমাৰ আছিল জব্দকৃত বস্তুৰ ৰেকৰ্ড খুলি দেখুওৱা নাই কি জব্দ কৰিলে নাজানো Section 100 of the CRPC Lordship knows 10 Marriott PW2 I do not know the informant and the accused persons in ward number 16 of Guwahati town, Sonali town. I have a shop. One day in Guwahati
PW2 also does not know. He did not see.
Yes, you'll also be gone through. Then, my lord, you will also kindly come to PW3. I do not know the accused so. I am the.
He did not see the actual seizure. He was told it was seized from the lady.
Yes. The result is gone. There were four also, my lord. We had three other staff. This is the police. Bailung was the lead DSP. Went to a place of occurrence after we apprehend Arun. After customers were there with the
PW4 sees police personnel.
yes, he police personnel. I will also, my lord. Barugahi.
He is also police personnel.
Police personnel. Then you will also, interestingly, you will also kindly see PW8. What is it? Eight. Amrit Kalita, retired SI police. On 6/9/2016, I was posted as second officer at Sonai police station. On that day, FIR was lost by SI police Sri Amarjyoti Bailung, alleging recovery of drugs. And received of the FIR, the case was registered, filed Sonai PS case number under section under section 22C of the NDPS Act. I was entrusted to investigate. Taking over the charge of the investigation, I examined the informant and the accused persons who were detained. On that day, I visited the place of occurrence, people sketch map, sketch of this same. I also recorded statement of the witnesses. On the same day, I interrogated the accused persons. On 7/9/2016, the accused persons were forwarded to court. The informant seized 3 mobile handsets and the SIM card were sent to the CDR. On 7/9/2016, the seized brown sugar was produced before the special court and samples were sent for FSL. I collected the report from FSL and CDR. Thereafter, completed the investigation, submitted the charge sheet under section 22C. Exhibit 9 is the sketch map. This is not relevant matter. You will also kindly see in the cross. The FIR was received in so about 3:30 p.m. The drugs were recovered by the informant about 1:30 a.m. at night. 1:30 a.m. at night. Along with FIR authorization, FIR letter was not submitted to the informant. I was not present at the time of recovery of the seized material. I found the drugs and the accused in the police custody, police station. It is not there in the statement of the informant that prior to the recovery of the drugs, he had searched by anyone. He was searched by anyone. He being Ayumal doesn't know anything. He says, I did not record this so. When I received the drugs in the police station, these were not kept in any sealed packet. While sealing the packets, I did not obtain the signature of any witness. At the time of sampling the drugs, no independent witness was present. This is how this seizure went. Now, there was no compliance with section 42. There is no record so far I am the records are available with me. No compliance section 50 and 52. Yeah.
And 50,
Hello?
non-compliance,
No, section 42.
and
The authorization and 50 and 52. How the search is to be conducted under section 50. It one says, my lord, that provision of CRPC 1973 would apply. So section 100, my lord, requires independent witness in the seizure. CRPC section 100, subsection 4 and 5, my lord. There was, as your lordship has seen, totally violated.
yes.
The last hearing, your lordship, there was short hearing, whatever 5 minutes, your lordship asked them specifically whether section 42 and 50 was complied with or not. Then they had taken time. They replied.
A recovery was made from an external bag, isn't it? Not from the body.
No.
So 50 will not be probably attracted, but about 42.
42 will take it.
Is there anything in the evidence saying that he informed his superior officers within?
I have not, lordship has gone through the evidence matter. I have not found anything.
Partial compliance.
What is there?
I'm looking only that part, my lord. This is 42, my lord. That is the authority letter or anything, my lord, on that bag, my lord. Because in the day of our, my lord, contraband recovered from the, my lord, convict appellant herself, my lord. From the bag, my lord. Then they, from the,
Whether they were contraband or not, seizure has to be proved.
My lord, that is the my lord PW6, my lord. PW6 is my lord, that is a police, yes, my lord, that is a who is my lord, there is
IO.
yes, my lord, not IO, my lord. There's a, yes, my lord. Omanjoti Borua, my lord. PW6. FIR is my lord, that is lodged by my lord Omanjoti Bailung, my lord. So he is Omanjoti Bailung, my lord, who my lord lodged the FIR. At that point of time, my lord, he was in the my lord, that is the operation, my lord. May I read, my lord, only this part, my lord, for my lord, regarding my lord, because he at that point of time was there, my lord. May I read that part?
Yes,
only?
yes, yes.
On last 6/9/2016, I was walking at Sunari police station after receiving information that a Bolero car with drugs came to Gohai Hotel. I went to Gohai Hotel with UBC, so-and-so, ASI so-and-so, and one lady constable. I made GD number so-and-so, that is exhibit 4, GD. Exhibit 4(1) is my signature. We found accused persons. We found drugs on the possession of the lady around. I informed the matter to the headquarter DSP. He authorized me to conduct inquiry. My lord, that part is, my lord, in the, my lord, that is the seat, my lord, that part is there. And if it is, my lord, that is, my lord, authorized by the DSP, then, my lord, it is under section 41, my lord. The authority made by the, my lord, gazetted officer. So 42, my lord, if it is, my lord, then I measure I measure suspected drugs and says exhibit 1 so and so signature is my signature. I also says the vehicle and by the accused person. Exhibit 3 is the seizure list, 3/4 is the signature. I examined the witness. I drew sketch. My exhibit 5 is my signature and exhibit so is my signature. Then, my lord, in the cross, I have examined Utpal Raskwa and Papu Gogoi. All seizure lists are prepared by me. I didn't seize the parts from where the suspected drugs, no written authorization was given to me. So that is, my lord, from the, my lord, that is the cross, it is clear. Is the authorization here there, my lord? That is, he received the authority from the, my lord, DSP headquarter, my lord. But that is not in the written form, my lord. That is in the, my lord, that is the cross, my lord. I have attached a signature over the seal of the suspected drugs. My lord, regarding, my lord, there is the 41, my lord, authority, because from the DSP headquarter, my lord. So this is the position, my lord. But, my lord, obviously, my lord, there is the superior officer at that point of time, my lord, was not present, physically present, my lord.
One is about the power to issue warrant and authorization.
My lord.
That doesn't take away the duty of the officer under 42.
My lord.
About recording of the information in writing, communicate it
Yes,
to
my
his
lord.
immediate
Yes.
superior officer.
Yes,
Those responsibilities remain.
my lord.
So he made a GD entry. Did he communicate anything to the superior officer?
My lord, GD entry is, my lord, there, my lord. It is, my lord.
Is there anything in his evidence that he communicated the contents of the GD
My lord,
entry to the superior officer?
my lord.
Immediately or within 72 hours? What was the time of the raid?
But time of raid is, my lord, that is
1 I found 3:30 AM.
So between sunset and sunrise.
between my lord, sunset and sunrise. Because, my lord, information received at, my lord, at about 11:30 AM, my lord.
So the second proviso to 42 has also to be complied with.
My lord, if it is after, my lord, sunset, my lord.
Yes.
But here in this case, my lord, it is, my lord, in the day hour, my lord.
Good.
Because, my lord, information received at 11:30 AM, my lord. They received the information, my lord, at 11:30 AM as per the FIR, my lord. They received the information at 11:30 AM, my lord. Then thereafter, my lord, that is the, my lord, they went for, my lord.
No. So when did they go to the hotel at night? 3:30 AM means night. Before sunrise.
My lord, in the cross of this one, you have to see, this witness is PW8, my lord. In the FIR was received on 6/9/2016 at about 3:30 PM in the afternoon. The drugs were recovered by the informant about 11:30 AM. That means
AM means my lord day hour.
they are and
On which day? Next day,
next day. Certainly.
17.
Yes, madam. It must be 17 because 3:30 PM FIR received and the recovery of the, by the informant was 11:30 AM. That means about 7 hours after. No, more than 7 hours. 11.
7 hours. More,
8 hours after.
Oh, 3:30 PM means there at night 3:30 AM it will be 12 hours.
No, 3:30 PM.
Next thereafter.
No, 3:30 PM. So today night at 3:30 PM, the FIR is received. And the recovery of the informant
How
was
can
made on
3:30 PM be night?
night. And recovery was made on 11:30 AM tomorrow. Haveli. Or 11:30 to Ratiba before noon.
That is what I am saying. So on 16th
My lord.
at around 3:30 FIR or information was received.
Yes.
My lord, FIR is lost, my lord, that is on my lord.
Subsequently.
6/9/2016, my lord. And my lord, that is the GD entry, my lord, that is also 6/9/2000, my lord.
Yes.
16, my lord.
What is the time of
My
the
lord,
GD entry?
in the FIR, my lord, in enclosing here with the extract copy of Sonari PS GD number so and so dated 6/9/2016. I beg to report that today on 6/9/2016 at about 11:30 AM received secret information from the reliable sources that Gohaigaon Hotel of Sonari so and so has been running illegal drugs.
Oh, that
So
means
11:30 AM is the
information-
receipt of information.
Yes, receipt of information in the day hour, my lord, 11:30 AM, my lord.
in the morning hour.
Morning hour. my lord.
Before noon.
And when did they go, at what time was the recovery made?
They say 11:30 AM. My lord, you will
How can it be 24 hours later or? He received at 11:30 AM also and made the recovery also at the same time.
The FIR was received on 6/9/2016 at
FIR may be later also. FIR may be done after the recovery
on
also.
16 itself. At 3:30 PM. About today 3:30 PM they received the FIR and next day, my lord, at
My lord,
11:30.
I have gone through the, my lord, that is the case diary entry, my lord. Because, my lord, regarding that is the time, my lord, I've just flag mark, my lord. Here, my lord, it is stated, my lord, they, my lord, receive, Pua Sare Haro Bozat, my lord, that is the Toka, my lord, Guponiyo Hongbad, my lord, they receive it, my lord. Then, my lord, Pua, my lord, that is Egarota Ponsolis, my lord, Egarota Gohai Hotel, they immediately, my lord, ran away to 11:45, my lord, at Gohai Hotel. And my lord, they conducted, my lord, that is it is completed, my lord, Oporahano Barota Pasot, my lord. This says, my lord, all this Podokia, my lord, Srimoti Mita.
So all within the matter of an hour or so.
Within the day, within 1 hour, 1.5 hour, my lord. So, my lord, they were taken to, my lord, here, my lord, also, my lord, this entry is there. That is Oporahno Barota Pointis, my lord. যে এতিয়া মহামান্য আৰক্ষী অধীক্ষক মহোদয় চৰাইদেউ জিলাৰ DSP হেডকোৱাৰ্টাৰৰ so and so ছাৰক তেওঁৰ আগত উক্ত সন্দেহযুক্ত ড্ৰাগছখিনি NDPS একমতে অথৰিটিৰ কামখিনি তেওঁৰ আগত কৰিবৰ বাবে মোক অথৰিটি দিয়াত মই অথৰিটি পাই ড্ৰাগছখিনি হেৰি কৰিবলৈ যত্নমান হলো. So my lord, it is in the day hour, my lord, itself, my lord.
So the next part is subsection 2 of 42.
Yes.
Where an officer takes down any information in writing, let us say GD entry.
My lord. Well,
Under,
that part.
under subsection 1.
Yes.
For records ground, that is not necessary. He shall within 72 hours send a copy thereof to his immediate superior official. Where is that part?
That later, my lord, I am searching, my lord. Though, my lord, in the entry, my lord,
All right, you search and flag mark if you can find it.
yes, my lord.
Now, what did he do with the seized article? What was recovered? 300 grams of heroin.
My lord, contraband recovered is 310.60 gram of heroin, my lord, and the test positive, my lord, in the FSL report.
Sealed at the place of occurrence.
My lord,
Does he say that?
my lord, in the deposition, my lord.
What did he do with it? I don't find it reflected in the judgment either. What happened to the?
My lord, may I pray for my matter may kindly be part out of a 1 day accommodation. In the meantime, my lord, I will flag mark all the things, my lord. Only, my lord, these
Yes,
two
all
points,
right,
my lord.
all right. You firstly, number one,
My lord.
the communication to the superior official.
Yes, my lord.
Within 72
Yes,
hours.
yes, my lord.
Number two, the chain of custody of the drugs.
Yes, my lord.
After seizure, whether it was sealed, whether it was deposited in the Malkhana,
Yes,
whether samples were drawn before the magistrate,
yes, my lord.
sealed and sent to FSL under
My lord.
proper custody.
My lord.
Yes. Right, third in part. Is the matter again on?
Fourth, my lord,
Need it?
or even third, my lord, but third is hearing date.
Third.
Hearing the difficulty is that if there are other hearing matters, many hearing matters, then
Part matter will come, my lord.
if part third comes on top of the list, I don't know, but. Up to you.
Third maybe. Either. Which one third?
Oblige.
For the hearing. Other.
Item 46.
Then we are in the IA for suspension of sentence, Lordship. It's a judgment of 36,025. At page 19, it starts.
What is the offense?
I'm
POCSO.
charged of section 4 POCSO, punished for a period of 10 years fixed term and a punishment of 3,000 fine. Now the reading of the medical report, the statement of the victim, there is no ingredients of section 4, firstly. Secondly, the age of the is proved by transfer certificate. Therefore, the benefit of 2 years is also not given.
Hearing on behalf of P. Sekya, Elite Council Respondent number 2, engage in another court. Pass over the.
The statement of the victim is at page 49. He is only the witness, and the other witness, there is no eyewitness except the victim. Lordship, I can read the other witnesses also. There was what they see. The girl voluntarily went. Lordship, there was no, as stated in the affair, there was no force. the other neighbors saw both of them together. It's not that they were doing something, but both of them together, the other witnesses saw them. Otherwise, there is nothing in the medical report at page 46. What you would kindly see. Opinion of the at 47. And most of the other witnesses are passerby, firstly. Secondly, Lordship would see the judgment at para 26, how it deals with the age of the victim. It's 32. Para 26, page 31.
W6, it appears that they were caught red-handed. They found both of them in the nearby jungle and they took them and cautioned them not to come again.
Yes, that was nothing forceful. That was my submission.
Huh?
It is under.
Now we will go into the question of the age, that also he has challenged. That doesn't mean prosecution has no burden at all.
Foundational facts.
That age group certificate has been an exhibit.
That has to be acceptable, whatever you have exhibited. You have to follow JJ Act, isn't it? We have to follow the JJ Act even as per Supreme Court's guidelines determining age of the victim also. Same guidelines are to be followed.
No, Lordship, first is the birth certificate, second is the matriculation certificate.
First is the notice that he has admitted in the first school lordship. After the second
No.
will come. And then
No.
JJ Act.
Journal Singh to some.
Section?
Section 94. if I'm not mistaken. Lordship, it's 94 of the JJ rules 2007, section 60 of the.
No, 94 of the Act, Presumption and Determination of
Yes,
Age.
yes, 94. May I read, Lordship? I have a judgment which quotes the section.
Reading it. Date of birth certificate from the school or the matriculation or equivalent certificate from the concerned examination board, if available. First is date of birth certificate
Yes, Lordship.
from the school. That means the date of birth certificate that was submitted to the school. Is it? School will not issue date of birth certificate.
That is there in the JJ Act, Lordship, section 2.
And
That
now,
is
Lordship,
in
what
JJ
is submitted here at Lordship, you to find at CGR list 52, page 52. It's a one school leaving certificate, transfer certificate of Bongaigaon MV. And at page 76, Lordship, the concerned witness one second. Huh? Lordship, sorry, 78. 78.
Page.
Page 78 of my appeal. I have appeared on the strength of the summon issued. I've been working as a headmaster of Belaguri MB School, Palangbari, Bongaigaon since 1989. Today, I brought the admission register transfer certificate of the victim. Relevant page of the admission register approved is a relevant entry signature as per admission register. Date of birth of the victim is 6/4/2006. Is a transfer certificate of the victim from LP school bearing 407 lower primary. Is the signature of the then headmaster of the lower primary, Sri Satish Chandra Nath, which I know. Exhibit 8 proof in original counter foil of the transfer certificate of the victim. Guri MB School, Palangbari, Bongaigaon. Exhibit 8(1) is my signature. As per Exhibit 8, date of birth of the victim is shown as 6/4/2006.
School certificate, admission, school produce admission register, date of birth was entered on the basis of the transfer certificate. Question is whether this transfer certificate satisfies the requirement of section 94(1).
In my humble submission, it does not satisfy the requirements of the section 94.
I think rules also say something.
Rules 12.3.3. 12.3 of the 2007 rules. Procedure to be followed in determination of age. May I repeat?
Yes.
In every case concerning a child or a juvenile in conflict with law, the court or the board, or as the case may be, the committee referred to in Rule 19 of the these rules shall determine the age of such juvenile or child or a juvenile in conflict with law within a period of 30 days from the date of making application for that purpose. The court or the board or the case may be, the committee shall decide the juvenility or otherwise the juvenile or the child, as the case may be the juvenile in conflict with law prima facie on the basis of physical appearance or documents if available, and send him to the observation home and in jail. In every case concerning a child or juvenile in conflict or the age determination, inquiry shall be conducted by the court or the board, as the case may be, the committee by seeking evidence by obtaining, firstly, A, the matriculation or equivalent certificate if available, in the absence whereof the date of birth from the school other than play school in which school first attended, and in absence whereof the birth given by the corporation or a municipal authority or a panchayat, and only in absence of the either 1, 2 or 3 clause A above, the medical opinion will be sought from the duly constituted medical board, which will declare the age of the juvenile child. In case exact assessment of age cannot be done, the court or the board or the case may be the committee, for reasons to be recorded by him, may, if considered necessary, give benefit to the child or juvenile by considering her on the lower side within a margin of 1 year. So that has been 2 years by some judgment of journal seeing. Now this lordship, if lordship sees 78, 78 is the, even the 78 admission register is not from the school first attended. It is the admission register of class 6.
These are rules of 2007 that was enacted under the 2000 Act. 2000 Act was repealed by the 2015 Act. But no rules were formulated thereunder.
Yes, Lordship, but
there are
the
no
act-
rules under the new Act of 2015. But if the rules formulated under the earlier Act is in conflict with the provisions of the present Act, then the Act will prevail. We'll have to go by section 94
Yeah,
only now.
94, yes. So, by 94 also I am covered. Lordship, I am submitting this for the purpose of suspension of sentence only, for the purpose of bail only for today. I have already spent around 7 months, 5 days after conviction and 1 month prior to that during investigation. Lordship allows me, Lordship has recently in a similar matter passed a judgment. If Lordship And these are similar punishment under the similar law, similar section. Yes. Right. There is some doubt regarding the age, because this is not certain whether that transfer certificate would fulfill the requirement of section 94. Because we do not know on what basis the transfer certificate was issued. He says admits he has no birth certificate. The birth could have been entered just on the verbal.
If that was that was done after the incident, that could be say, we can say, but it was done prior to her, it was entered prior to her.
No, that is not, we are not saying about procuring a certificate to show a lesser or higher age.
On that, whether this
Is
is,
that-
whether this is admissible or not, that part.
Whether, yes, that admissible part, and there is a further question. Is the basis on which the entry in the register is made, school register is made. Whether it is on the basis of a birth certificate issued by the authorities, whether it is on the verbal statement of the parents, because that happens in many cases. The Supreme Court has observed that as well. I think there is a recent judgment of Her Lordship in Nagaratna regard. Delivered a judgment on.
That entry is from from the primary school that she has first admitted. Actually,
This is not primary school. The
Transfer
transfer certificate from another school, and that school, how it recorded the date of birth, on what basis, that is not known on the evidence on record. So there is some, at least some point for argument as far as that is concerned, because other evidence indicates nature of a something consensual. They were discovered, sort of. So if the age part goes, the case goes. Potentially, potentially. I'm not just commenting. This is just. So perhaps a fit case for suspension of sentence is made out in that sense. They will pass orders.
I dispose of.
Aye.
Yes, yes.